that we're going to be soliciting questions, subjects that the membership would like us to address. We are probably going to discuss things like discovery, and a good question came up this evening, like why do you guys have docs over in those English courtrooms? And we're not going to ask them about the wigs, so that's way too sensitive. But we're going to be going back and forth talking about these kinds of things. It's going to be a kind of get to know you better session, and if it works well, we will have future contacts with them like that. Now, on their side of the Atlantic, the young lawyers group in the Middle Temple wants to participate. We're doing it at the courthouse because we have a theoretical capacity of 499 attendees. And we're also looking at the possibility that we may be able to live stream it through other social media if there are people around the world who want to see it and just don't have access to Zoom. And there is interest as far away as Australia and Hong Kong and things like that. Just a few people here and there, but very strong interest over in England, Wales, Scotland, and Ireland. In fact, we had to scale back the scope of it a bit because in Great Britain, they actually have 3 different systems. They have England and Wales, Scotland, and Northern Ireland. And we had folks over there that were enthusiastic about talking to us about all those 3 systems, plus someone who was also practiced as a barrister in the Irish Republic. And we had to kind of dial it back a little bit. But we're still developing it. So if any of you have any questions, and the premise is, we all think we know something about each other, but we probably really don't know what we think we know. So if you have questions or suggested topic areas, just give it to us. It's going to be a lot of fun. We're going to have it. I'm going to be in my courtroom, so that if people want to come in and watch it on the big screen in the courtroom, they can do that as well. They don't have to while watching via computer. So that's really it. It's going to be a lot of fun.
All right. Thank you. Next, on that same day, actually, so November 12th, yes, is when the barristers panel is at lunchtime for us because of the time difference over there in England. But that evening, we will be hosting our 2nd annual Friendsgiving. Last year was the first year, so it went very well, and we're going to try to do it again, pandemic or not. Allison Smith is our events chair this year, and she will be setting up Friendsgiving. We are doing it with many other inns and organizations. And this is a picture from last year. We had a great time. The plan is to have, for those who want to attend in person and donate goods in person, to still go to Big Storm. So anybody who wants to join us at Big Storm, we will be sending out more announcements and let you know more of the time and everything like that. But that is the plan so far this year. And we will also have some sort of virtual option. We're still figuring out the details of that. But either way, it's going to be fun. And we really hope that everybody participates because we won last year and we want to win again this year. We can't let the other inns or organizations beat us because they sometimes beat us during the barbecue, and that's enough. So this year we will be likely supporting Kind Mouse, and they feed I think they call it the hungriest of the hungry children of Pinellas. Their need has gone up exponentially, especially since schools got out early last year and aren't really back yet this year. So we were able to donate a little bit of funds to them at the end of last year, and we'll be doing the food drive to donate to them this coming year. But like I said, Allie, we get more details out to you sooner, closer to the event, and once we have more of the details settled. For those of you, if anyone has not sent their dues check-in yet, please go ahead and get it into Jeff so that we can get everything straightened in order and have all of our information to Americans of Court timely. And then on to tonight's presentation. It is our master's panel, how to not get your rear kicked in court. We have an incredible lineup of masters. I'm going to do some very quick introductions of them because if we did real introductions of all of them, it would take the entire night. So I did them in order of who was barred in Florida first. And so we have retired Judge Jack Day.
Hey, thanks a lot.
Who, does anybody want to guess when he was barred in Florida? It was 1977, by the way. And he, like I said, retired Judge Jack Day. While he was on the bench, he was in criminal court, unified family court, and civil court. So he has a varied experience in all the things. And fun fact, he can carry on a conversation in Spanish. The next is Fred Zinover. He was barred in the year of my birth. So it's a really good year. And so he has that many years of experience. He is a criminal trial. He was Florida board certified in criminal trial law from 1993 to 2003 and is currently Florida board certified in civil trial law. Before it was criminal, now civil, since 2006. So a wealth of experience there. After that, in the same year, is Lee Reitmeyer, which hopefully he'll be joining us soon. But Lee has also been around the block, done some things, seen some things, and he is always available to really anyone who calls him to ask for any advice or anything like that. He is a great asset, not only to the end, but really to anybody. The next, oh, I'm sorry, I didn't put Lee up there. Hey, that's Lee, look. After Lee, we've got Bob Persante, who has been barred in Florida since 1983. Bob, I would say, is definitely everyone's go-to when you talk to anyone, not just in the inn, but outside the inn, and they say, who should you ask about XYZ? Bob's name almost always pops up. He's won, or seems to have won, at least every trial lawyer award there is. He's been to every trial school, and he even teaches at trial school. So he's obviously somebody who this panel would not be complete without. After that, we've got Hamden Baskin. He is the counselor of our inn, and he is a partner at his firm with Jeff Eisel, our treasurer, and with Lee, who was just discussed. He was barred in 1984. He went to undergrad at FSU, but then came to his senses and went ahead and got his master's in tax at UF after that. So, you know, things get better as the years go on. We've got Sharon Vesley. She's been barred since 1994. She's a shareholder over at Trenum Law, and she has the most colorful picture of anyone. And she is a double hatter, which, oh, who's calling? That's exciting. After that, we have Bruce Denson. Bruce has also been barred since 1994. He is the author of the book Lawyer Up, Work Smarter, Dress Sharper, and Bring Your A Game to Court and Life. So I'm sure he's going to have plenty of experiences to share with us tonight. We've got Chuck Tillman, who has been Florida barred since 2001. He's got his LLM in tax. He's got extensive trial experience from working in the insurance industry. And he recently, within the last year or so, formed a firm with our former Barney president, Misa Everest. We've also got Clifford Wells, who is a Florida board certified civil trial attorney since 2017. And he's been Florida barred since 2002. And his firm has obtained multiple multi-million-dollar settlements. So lots of great experience on our panel tonight. And there's a quote that one of our panel members thought was very appropriate for what we were discussing tonight and the concepts of what we're discussing tonight. This is a lot of the words of it. When he was explaining the quote to us, he gave us the Cliff Notes version, and I'll read that to you. The Cliff Notes version is, "It's not the critic that counts, but the man in the arena." And that's Cliff Notes by Bruce Denson. So if Hamden, if you want to go ahead and take it away.
Hello. Actually, Lee and I are in mediation right now, so we're double teaming. After I spend a few minutes, when Sharon comes in, I'll run get Lee and I'll swap out with him. It is unbelievable the quality of lawyers that give their time willingly to help lawyers with less experience benefit from their mistakes. And I would be a prime candidate to let you benefit. We could spend a day together, but apparently we only get to tell you a few things that maybe have made us better lawyers kind of the hard way. And one of the things that I have found is that as you get busier and busier, you have less and less time sometimes to make sure you're prepared for something. So particularly in motion practice, which can be really important, obviously, when you prepare the motion, it seems to me that there's always the possibility, and this never happened to me, but I'm going to tell you what could happen, that you get your motion completely prepared with all cases in it, have it ready to go, have copies ready for the court, have copies ready for opposing counsel, so that if on that fateful day you had to find out that you had to go get your kid from school just about the time you thought you'd kind of brush up on getting ready for the hearing, you could grab that folder and, very quickly get up to speed because you have everything in there. You don't want to get caught in a motion without being thoroughly prepared. I can tell, Bob can tell, everybody on this panel can tell when the other lawyer has been caught kind of short. And it can get pretty serious if your client's paying you big money to be there. And of course, what you want to do, obviously, is check your case law for updates just before your motion hearing if it involves a lot of that. So that was one of the things that I learned early on, because as you get more experienced, your cases get harder and they have more at stake typically, and you just have to just drill down, and your time's going to get short. Most of the folks on the panel probably would tell you that they hit north of 60 hours a week. And weekends and evenings, particularly for trial lawyers, is what happens. I did also want to tell you, and involve Bob Persone. He and I were similarly aligned, but we had different clients. But I had the young kid who somehow got himself named as a trustee over his grandfather's multi-million-dollar trust. And I just felt like I wasn't sure the man was really hearing me, and he was going to be deposed by a very good lawyer. And that's another thing. Never underestimate the other lawyer, and never tell your client that that lawyer's not that great on the other side, because once that happens, nothing good will happen with that at all. It'll either get back to the lawyer, get back to someone else, or your client will get taken to the cleaners. But a very good lawyer on the other side. So I say, Bob, you're familiar with the case. Would you spend a couple of hours kind of putting this client through the paces so that I make sure that he's kind of ready, because I think he doesn't listen to me anymore. So Bob did. And Bob is one of the greatest lawyers I've ever met in my life, one of the best trial lawyers. And I enjoy litigating with him, but boy, you got to have your A game. So I figured who better than Bob Persani? So Bob put him through the paces, and then my client goes to the deposition. And first question was, I want to show you a series of checks your grandfather signed to you for $9,000 each. Is that your grandfather's signature? Well, yes. Well, Bob probably asked him that too, and he said yes. The lawyer said, well, who made that signature? Well, I did, but it's his signature. So let me get this right. You signed your granddad's name, and so it's his signature, but you put it there. Yes. Well, when did you do that? Because the checks were signed when you just testified he was in a coma. Oh, I did it a few days before. Okay. So kept going on. Next thing, your grandfather was very good to you. Did you go to his funeral? I mean, you kind of maybe don't bother to ask that, but this lawyer did. Well, no, I didn't go to the funeral. Well, why not? Well, surf was up. We had a hurricane come through. So, you know, this young man was taking a major portion of the trust that was being attacked. And the other thing, do not underestimate Facebook. Again, I didn't pull Facebook. I recommend you do it. I recommend you do a background on your client. But this same lawyer asked my client, well, you had to pick up all the gold in Las Vegas. Yes, lots of gold bars. Okay. Did you go with anybody? Because he'd already said he went by himself. Well, not by myself. Well, actually, you had plane ticket for two that you charged. Well, yeah, I brought a buddy because the gold was so heavy, it would take a couple of us to load it. Well, he commissioned a private plane out there. And then the lawyer says, well, was it all business or did you play while you were out there? Oh, it's all business. He goes, well, let me show you that you do Facebook. Well, yeah. He said, well, let me show you a picture. And it's a picture of my client leaning crooked on a lamppost with a bottle of liquor in his hand, and inscribed underneath his picture was drunk and crooked in Las Vegas. So given that the whole case was about my client's veracity, that was not a great thing. And I don't know what you do to pull that out of your client, but ever since then, I have asked clients about Facebook postings. You know, I run a TLO background search on my own clients. I don't tell them I do. It costs $50. And you trust your clients, but you verify, because you don't want to get caught like that. So anyway, those are just a few mistakes I've made. I have plenty more. Just give me a call. We'll go over them. So. All right. So, and I'll go get Lee, but I think Sharon's next.
Okay. Well, good evening, everyone. It's humbling to be able to tell you how I once got my ass kicked, but here it goes. I was a young lawyer, I don't know, mid-90s, one of my first cases, and it was a potentially solid medical malpractice case. Very nice lady comes to meet me and my partner, and she's upset because her husband went to the VA hospital with almost every symptom you could have that would scream heart attack. And he's waiting and waiting and waiting and waiting and waiting and waiting to be seen. And he has a heart attack and dies right there at the hospital before anybody bothers to see him. And I did all the research necessary, you know, under the Federal Tort Claims Act, learned what I needed to learn, preparing the case, getting the background, and it was one of my first client relationships. Very sweet woman. She would call crying. We would have these counseling type sessions, and I really felt bad for her. And we're rocking and rolling in the case, file the lawsuit, and it's time for her deposition. And we go to the U.S. Attorney's office for her deposition. And we're there, and this opposing lawyer, who was already snarky to begin with, she comes in and she has a box of documents. And, I'm looking at this box, and I'm not really recognizing that this is, the documents I've produced. These are different. I can't understand what she has in this box. So I'm perplexed from the moment we walk in. So she proceeds to depose my client. And she's asking her about her loss of companionship that we are claiming, and the loss of consortium damage claim that we are claiming. Her husband died. And after she hears all of the level of upset and suffering that my client has suffered, she proceeds to pull out files from her big box, and one after the other, after the other, after the other, were all of the domestic violence police reports reflecting that my client tried to kill her husband on numerous occasions. There is one incident in which she literally had a gun pointed at her husband when the police arrived. I am shocked. My whole body just gets hot. I can't even believe this is happening. I'm trying to keep a poker face. My client is pouring sweat and wants out of there. Starts to hyperventilate, we take a break. So we go to the restroom together, and she says, I really want to end this. I can't handle this. And, what do you think this is doing to our case? It was very fitting that we were in the ladies' room at this time. And I said to her, your case is in the toilet, literally. How can we claim damages for your loss of companionship when you wanted to kill him yourself? This isn't gonna fly. So, we calmed ourselves. I said, look, finish the deposition. We cannot do this again. Just finish the deposition, take a deep breath, answer honestly and truthfully and directly. And we will be done with this deposition, and we will do our very best to see if they will allow us to accept their last offer. And so that was an ass kicking, and I will never forget it. It was absolutely horrible. And so what's the lesson that I learned? Investigate your client and do it on your own, in my opinion. Look at everything there is on the internet, whether it's, Facebook, Instagram now, at one time it was MySpace, everything that's out there, just get it, top to bottom. Then have the meeting with your client face to face so you can see their body language and ask them, look, tell me what you think the other side is going to say about you once you're deposed. Is there anything in your past, anything they might bring up? It's good to know ahead of time so we can deal with it. I can deal with things a lot better if I'm not surprised. And, we can go into this with a lot more credibility if we, are upfront about the facts. So just, confidentially tell me everything you think. And then sometimes they tell you more than you really need to know, but better that way than getting surprised like I did in a deposition. So hopefully that never happens to anybody, but there is a way to avoid it, and I wish I would have thought of that. So that's my lesson. Thanks.
All right. Lee, welcome.
Hey,
You're
Right.
up. Yes.
okay, here's my story that falls outside of the statute of limitations. we represented I don't think they're Fortune 500, but very big company that provides management services for professional associations. And that's about the best I can say, because the rest is probably confidential. And one of the professional associations that my client managed very profitably mutinied, ended up getting my client fired, which led to our bringing a tortious interference claim. And there were claims going both ways. It was arbitrated. And we broke the conspiracy. And we proved how the people we were managing mutinied and caused us to get fired for lots of bad reasons. And for the damages, I was told, don't worry, the CFO's got it under control. We're covered. Okay. What's the value of this relationship? $2.5, $3 million. Great. How do I get there? Don't worry, we're covered. Okay. And Mr. Big, the CFO, couldn't get with us during the months before the hearing. And, they finally managed to get him to fly down. And I'm explaining what I'd been told he's going to say. And he said, well, I can't explain to you what the contract's worth. I said, why not? He goes, well, because I buy and sell contracts. And it's confidential information. And so we went into the hearing having him give a half-assed version, which is all he was willing to give. And we ended up winning a stunning victory on liability, but getting goose-egged on damages because our client's internal report showed it was a break-even contract. And so we also got a big fee award because we'd won on some other small count. But holy smokes, don't let yourself get in the position I let myself get into, where you believe the client's in-house counsel saying, don't worry, we got it covered, because we didn't. That's my story. And I guess it's a variation, Sharon, of yours, isn't it?
Yours sounds a little bit more lucrative than mine.
And it was painful. I finally gotten to where it doesn't keep me up at night. It's been like 9 years. That's my story.
My
Can I go
goodness.
back to my mediation? I love you all.
Yes,
Okay, bye.
thank you.
Thank you.
Fred? Fred, you need to unmute yourself.
Can you hear me now? Okay.
Yep, there we go.
I'm Fred Zinober, and it's a very humbling experience to know I'm the second oldest here next to Jack Day. So that being said, one of the things that was mentioned in my bio is that I used to do a lot of criminal law until I wound up getting my ass totally kicked in a well-known case. For many of us that are old enough to remember it, I represented a guy named Obert Chandler who didn't fare too well here, so I switched over more to doing exclusively civil. But the best ass kicking I've ever gotten, I'm going to give two stories. One of the best ass kicking I've ever gotten from, quite frankly, the best ass kicker I've ever known, which was a criminal matter. And then I'll tell you a little bit about one that I was sort of an unknowing participant in a civil case where it was very nice to watch the other side get their ass kicked. But for those of us old enough to remember, there was an expert in these parts named Sid Marin. And I've been doing this for a long time, as I guess everybody knows now. I've been doing it for quite a while. And Sid still was the best expert I have ever known. He was a neuropsychologist that practiced on Azeel Avenue. And it was always a run, whenever there was a psychological issue at all, to Sid to see whoever got Sid first won. And basically, I was defending a young man in a penalty phase on a murder case. I'd already lost the liability phase. He was found guilty of murder, and I inherited the case. And some other people had worked with the public defender's office, had worked the case up first. And unfortunately for them, and more unfortunately for me, and most unfortunately for my client, the state had already hired Sid Marin. And every other single case that I had had with Sid Marin, I was fortunate enough to put my track shoes on and go hire Sid first. And I got him on my side and never failed to be successful. But now he was on the other side, so I was going to go ahead and take Sid on and see if I was the first guy that could really do a number on Sid. And the young man was, he had a very difficult childhood, and that was the basis of my defense on why the jury shouldn't send him to death row. And so I went out and I hired one of the best experts, lady from University of South Florida that was an expert in people with criminal backgrounds that have very difficult childhood, written a lot of books, and she was going to be my expert. So the state goes ahead and calls Sid, and I went ahead and thought I would be a hot shot and cross-examine him. And I started going through, well, Dr. Marin, have you ever done this? No. Dr. Marin, have you ever published in this area? No. Dr. Marin, have you ever testified relating to, children with deficient childhood? Well, not really. And then I asked one question too many. And Sid got that little gleam in his eye that I had seen many times before and always welcomed when the other side asked the one question too many. And I don't remember what the question was, but I remember the gleam in Sid's eye. And I remember Sid just saying, okay, in his eyes, all right, Mr. Zinnober, that's one question too many. And now I'm gonna go ahead and rip your head off. And he just went on in only the Sid Marin way of how, Mr. Zinnober, your client is an absolute nutcase. He's an absolute pathological killer. And just went on for about 5 minutes. And I did what every good trial lawyer knows exactly what to do under that circumstance. Although it was the first time it ever happened to me, I sat my ass down. Okay. And that was the end of that. Sid came walking by my desk on his way out, and he just gave me the wink. And I got the message, don't ever do it again. So what is the message out of that little episode? And it is, when you're getting your ass kicked, sit your ass down. So that's the lesson we learned there. Then let me give you one more story and I'll pass the baton. And that is, after getting my ass kicked enough times, and I see Bruce here and he knows what I'm talking about, how you can easily get your ass kicked when you're on the defense side of a criminal case. So I said, no mas, I'm gonna try to even the odds a little bit. I'm gonna start doing some civil work, and which is what I've been doing for over 20 years. I don't know how long since then, but here's a little lesson for the civil attorneys here, particularly those that do defense work, because I then started working for a lawyer in Tampa named Barry Cohen, who many of us know. He was a very, very adept trial lawyer. And I had a case where, for those of us that aren't that familiar with it, one of the things that you're allowed to read into evidence is the deposition of the opposing party. And so one of the best things, and one of the lessons that I learned doing plaintiff's work, is a really good thing to do is to videotape the deposition of the opposing party, particularly if you're the plaintiff, and then use the videotape instead of calling the witness live at trial. Why? Because the witness is probably not going to be ready for the deposition and he is going to be very ready at trial. So I got in the habit of videotaping the corporate representative or whoever the main party was on the other side of who I was suing. And I went up to Nashville to depose the corporate rep of the entity that I was suing for a negligent security case. He was the owner of the apartment complex. And the depo went on for about 2 hours. And, I was doing okay, But at the end of the depo, when I was about to wrap everything up and doing the typical, let me look at my notepad to see if I asked all my questions, and I'm rustling through, I had no idea this was going on, but the opposing counsel on the other side of the table happened to be a very attractive young female. So while the videotape is rolling and I'm looking through my notes, the corporate representative goes like this to the unattractive female. He goes like that. Now, I didn't know that. So we're getting prepared for trial. In this case is getting ready to go to trial. And we're watching the videotape. And at the very end of the videotape, the guy goes like this. Okay? And so one of the first things we do at trial, after the other side put on their opening statement on how we had no case and how their corporate representative was going to show that there was nothing wrong with the apartment complex, we had nothing to do. Okay, thank you very much. So we played the videotape of the corporate rep depo. And after he finished saying everything that the terrific defense lawyer told the jury he was going to say, guess what he did? Right where they were sitting, he goes on the videotape, just like that. Well, there was a gasp that came through the courtroom from the other table, from the jury box. And guess what the last thing they saw before they retired was? The corporate rep going to the defense table. Now, that wound up turning out a lot better for us than the first story that I mentioned. So what's the moral of that story? There are two morals. One, if you're doing a video depo of your client or your witness and you're defending it, make sure you tell that client or that witness that under all circumstances, that video is going to be running and everything you say is going to be on the video. The more important lesson is this one. We had a hunch, although as good as the other side was, that they were not going to sit through the 2 hours or whatever it was worth of the video. And we didn't play the whole 2 hours. We put in certain clips, but we felt that they would not watch the whole video and they would miss that. And guess what? We were right and it killed them. So the other lesson to be learned is watch the video and look at all the evidence. So those are my two war stories on how to get your ass, how not to get your ass kicked in court.
Thanks, Fred. Bob, you're up
Let me
next.
turn that over.
All right, I'm Bob Prasante. All of these stories sound very familiar to me. We've all been there. We've all had crazy things happen. And one of the things I want to talk about is preparing your case. I had an expert witness who used to tell me the most difficult thing in the world to do is just pure thought, sitting down and really thinking out your case. And one of the things that I do that I'm not sure many people do is that I always prepare my opponent's opening statement. I was out in Los Angeles. I was asked to help a guy who was going to trial, who's a young, very talented lawyer at a personal injury firm. And we go through his case and everything. And I said, what is it you don't like about the case? And he said, there's an experienced insurance defense lawyer on the other side. He's kicked my ass the last 4 times in a row. He's just more experienced. He's a son of a bitch. And I've just gotten to the point where I think juries are stupid. Okay, that's what he said. I mean, he was upset. He was starting to tear up. And I said, well, give me his opening statement. he's going to get up on his hind legs and he's going to say something. You've painted a pretty good picture of your case. Give me his opening statement and do it the way he did, with his inflection, with the points he would make, with the way he would look, with his mannerisms. And he did. There were several of us in the room that watched this whole thing. And then he sat down and I said, now tell me what's wrong with what he said. So imagine that you have to give a speech and your opponent's going to give one after you, and you anticipate everything that your opponent is going to say. And then you reference it in your speech and gun it down before they actually even make that speech. I had a friend I told to do that in a securities arbitration, and he told me that as the claimant, when he got done with his opening statement, his opponent said, I had a lot more to say, but really, Mr. Davis has already made most of my points, okay? He's already discussed the stuff that I wanted to talk about. So I do that, and let me tell you why I do that. First of all, we tend to lose objectivity in a case. In other words, we see everything through our side, but we're going to have neutrals, either a judge or a jury or arbitrators, decide this case. You could have been on the other side of this case. And so once you start looking at the case from their point of view, you begin to see what they're going to take advantage of. How are they going to portray the facts? If they're going to exaggerate certain things, if they're going to overstate their case, overstate it in your opening statement. Oftentimes when I'm sitting there, one of my partners, I always give my opening statement to them before I go to trial. I give the opponent's opening statement as well. And a lot of times my partner, Zach or Darren, will say, you know, after they get done, your opening was better. So what does that do for me? I have approximated what they're going to say. I've anticipated what they're going to say. And what it does is it reduces the chance that you're going to sit there shocked that they have a take on the case, that they have a way of bringing the case forward that you didn't think of. Okay. The other thing is when you realize that your opening for them was better than the one that they gave, it gives you a great amount of confidence because you realize that they've missed points and that you really see it. Same thing when you are going to cross-examine someone. I do a lot of securities arbitrations. There are no depositions. And so what happens is I have to approximate what the testimony is going to be. I call my opponents in hostile direct. I call the branch manager, I call the broker, and I take them through what I need to get from them. And I know at various points, they're going to go this way or this way. They're going to agree with me or they're going to disagree. And I have a strategy set for each one. I actually visualize that. I visualize myself taking the person through the questioning. When I am looking at documents, I am envisioning the questioning that I'm going to use with regard to that witness and what the witness's responses are going to be, and then what my reaction is going to be to those responses. Taking it even a step further, the reason why I got involved in the Trial Lawyers College, which is with Jerry Spence, you know, the legendary trial lawyer, is that they take it a step further. And instead of just visualizing things, they act out scenes. They see all trials as being scenes, like a scenes in a movie. You know, you got a storyboard, you've got that. They have storyboards. And they want to know what are the scenes in the case, and then they reenact the scenes. And they actually even do that, and I've done that with my own client. Let's take me to this room and reenact it. What did the room smell like? Who was there? Where were you standing? Give me a full description. I want to be in that room with you. And then we roll reverse with everybody. You can roll reverse with your opponent, with the jury, with the witness. All of that is to give you a full understanding of how the trial is going to go, and how to deal with the uncertainties that arise in every single case you can imagine. It also, when you think it out, you start to realize the vulnerabilities of your own case. The sooner you do it, the sooner you can go ahead and get the discovery, kind of patch up those vulnerabilities, and really learn the case the way you're supposed to. Thank you.
Thank you, Bob. Bruce?
All right. I wanted to tell a story from 1998. It was my last case as a prosecutor, and it still kind of lives with me to this day. And we had a saying at the state attorney's office, if you bring in a dog, you have to walk it. And this was a pretty tough case. And I couldn't leave the office without trying it. So it was my last trial as a prosecutor. And it was against Judge Hellinger when he was still practicing as a defense attorney. And it was a difficult case from my side because it involved an allegation that a young man had stolen from a bank by putting $20 bills in where $1 bills went in an automatic teller and feeding himself that money that way. So it was very complicated evidence that needed an accounting expert and a computer expert to come in and explain. And by the time I was about finished with my case, I looked over and my presentation was so boring that I put a bailiff to sleep. Not just a jury member, but a bailiff had gone to sleep in the middle of my presentation of my case. And then I compounded the error by commenting on it in my closing argument, which I would never do again. That makes you great friends with all the bailiffs at the courthouse, to be sure. But my real takeaway from it was kind of like Bob was just saying, you really need to think through the presentation of your case from a visual point of view. Today's jurors are just so visual in nature. You just standing there and talking to them is not going to cut it anymore. You've really got to have boards or PowerPoints or slides to convey your message so that you keep your audience engaged. So that was the story I wanted to tell, and I'm really glad we started with that Theodore Roosevelt quote, because I hear all these stories, and it's inspiring to me because these are attorneys that inspire me. And if these are attorneys, if I know Shireen is out there getting her ass kicked on something, I don't feel so bad when it happens to me, because it's going to happen to you if you're out there trying cases. It's no matter what you do, it's going to happen. But you've got to keep trying, and you've got to keep doing your best, and looking to some of these stories for inspiration. Hopefully you avoid some mistakes, but hopefully they inspire us all to do a little better.
Thank you, Bruce. Judge Day? You need to unmute.
There. So now that Claudia has officially established me as the oldest guy in the room, I want to say it's good to see everybody. You know, I hope to get to see you for some time to come. Okay? I wasn't going to do this, but in light of the stories of client problems, I gotta pile on. When I was not quite a baby lawyer, but when I was a new insurance defense lawyer at a firm trying my first insurance defense case with my senior partner, who I won't name for reasons that will become apparent, but who was a fine old gentleman from Tennessee. This guy, I never heard him say damn, okay? But we were defending a case against a very good plaintiff's lawyer, Phil Rogers, if anybody remembers him. And Phil put his plaintiff's husband up on the stand to talk about his consortium claim. And he said, oh, we don't have any problems. I don't have any problems at all. No damages. So, you know, we're walking away afterwards, leaving the courthouse saying, man, what was the strategy here? What was the intricate design behind this, you know, subtle move? And my senior partner turns to me and said, I'm going to clean up the F-bomb here, okay? He says, Jack, if your own client doesn't F you, nobody will. So just something to remember. I see nods of recognition among some of the lawyers. So, but most of the time, let's face it, most of what we do is not in front of a jury, though we need to spend a lot of time preparing it. Some of the cases some of us get don't support economically an exhaustive trial preparation for that matter. But we all have arguments in front of the court, and that's kind of where my mind went. I practiced law. I was a lawyer much longer than I was a judge. I was a board certified civil trial lawyer, practiced 29 years, then I was a judge for 12. There are two ways that you learn, two kinds of things I learned. One is from my mistakes, which we've talked about some, and that's when you learn the best. Then I had a second layer of learning when I got to be a judge, and I looked back and I saw people doing what I had done. I said, boy, that is really stupid. So what I learned from my own mistakes, I think most of all, was that if you're able to get a judge who listens, which is not everybody, but if you get a judge who listens, who will engage with your argument, listen to what the judge is asking. I'm ashamed to admit this, but I think the dumbest mistake I ever made in that situation was to basically say to the judge something like, well, that's really interesting, Judge, but the real point is so-and-so. If the judge likes a point, it's going to be a good enough point to hold up under the tipsy coachman rule, and you don't have to try to enlighten the judge about your more subtle the proceeds of your legal research. So I wanted to share that. But then as a judge, watching people do things that didn't work, this is a late add-on that came to me, but at some point when I was a judge, I realized, I don't think it was ever unfair, but there were times that I really liked to hear arguments from people that were happy. If you came in happy, I see Fred smiling. If you liked your case, if you liked what you were doing, if it kind of conveys, I believe in what I'm doing. I think one of the guys I associated with that with most was Tom Masterson, the late son of our founder. Tom was always happy in court, to be like, yeah, he's always smiling. And, it's, if you look at argument as a sales technique, I believe in my product. I'm glad to be here. I'm going to make you believe in my product too. It's great, Am I coming through okay? I'm getting a message that okay, good. So the other thing, and I think somebody's alluded to, this has been kind of alluded to, but put yourself in the shoes of the judge. That's kind of flip to say that, but really think about, like, if I were the judge, what would I want to hear? What would I need to hear to rule for this person? What would affect me? What would be wasted on me? And in that regard, bear in mind, judges are on they're on a justice assembly line. They've got a lot of back pressure coming at them of caseloads and things to be heard. They only got so much time, and you need to exploit that to the maximum extent possible in terms of what are the phrases that are going to get their attention. What are going to be left with them? How much time have they got to think about this? What summarizes your strongest point? And it's also good to consider what happens if the judge rules the wrong way, because a wrong ruling in a motion hearing can be changed all around the trial. So if you go first as the moving party, try to spend a minute or two with a short recital of just enough details about the case to orient the judge. If you've been before that judge before on the case, you might remind the judge of the case. You look at the judge's face and you'll be able to tell whether or not the judge remembers the case or not. And even if the judge doesn't, you can orient him to, this is a case about so-and-so. When you do that part, be neutral. That's not a time for advocacy. That's a time to impress the judge with your straightforwardness, and you're doing the court a favor by sort of orienting to where things are at. I got a page and a half here, and I only got one thing left, and it says, don't slave over a brilliant or even a not so brilliant memorandum of law where we put in a lot of time and you come up with this product that's persuasive, elegant prose, or maybe not so elegant, but it's a good case line and makes your arguments. Don't do that and then walk in at your 2:15 hearing and lay it on the judge's desk. That's not the time that's going to have an impact. Find out, just it's going to have impact if it gets to the judge ahead of time. If it's a judge that'll look at stuff like that, which I think is most judges. And then that brings up, find something about the judge's preferences. Don't be scared of JAs. You know, some are pretty scary, as I recall. But you know, if they're scary, you might even be worth going to talk to them in person. But you know, what does your judge want? You know, what will work with your judge? You know, if, hey, I was thinking I'm working on this thing. I'd like to send it. I'd like to email it a few days ahead of time. Is email okay? You want hard copy? Does he insist on hard copy, he or she? That kind of thing. Find out what they want. Find out what works. It's not, I think that one of the dumbest things I did as a practicing lawyer, excuse me, in motion hearings was I approached it as a performance, like I was the actor on the stage, presenting, making the best presentation possible. I was also the playwright, where I've got my script and I'm going to deliver it, and that's not how it's done. That's not what works. It is more interactive than that, and it begins with thinking about not what it is you got to say, but think about what your audience needs to hear. So that's what I've got. I think that makes it Chuck's turn.
Yeah, first I want to thank Clarka for the kind introductions, because honestly, when I was asked to be a part of this panel, my first thought was, whose trial bag do I have to carry for this virtual hearing? And the answer is Shireen's, if anybody wanted to know. But I don't, you know, going near the end here, I'll keep it really brief. I don't have really great ass-kicking stories. I do have one that happened to me when I was a baby lawyer doing insurance defense work, and I had to cover a very sort of rote hearing, UMC thing in Seminole County for another lawyer, not even another partner, but an associate. And I go over there, and all the lawyers in the courtroom, and Seminole County at the time, and maybe still, was known to be very plaintiff friendly. And I'm doing defense work. And so I get there, and the lawyer right before me on the docket was really getting it handed to him by the judge, and he truly was not prepared for the hearing. So that his hearing's over and mine comes up, and it was I wish I could remember exactly what it was, and I can't, but it was just something very routine. And the judge looks at me and says, "You're here for Mr. Lopez." And I said, "I am." And he said, "Well, is Mr. Lopez available next Thursday for something?" And I said, "Gosh, Your Honor, I don't have his schedule in front of me, but we can get this worked out, you know, by the end of the day. It won't be a problem. I've already talked to opposing counsel about this." And he said, "Counselor, I don't need an empty suit in my courtroom." And I just kind of looked at him, and I looked at the bailiff and just kind of thought, did he really just say that to me? And he did. And I said, "Well, Your Honor, as I said, I can get this scheduled by the end of the day. Opposing counsel has no problem with that." He goes, "You're going to go in the hallway and you're going to get it scheduled right now, and you're going to come back in and tell me when it is." And so I did. And that's a very basic lesson to learn. And I tried to think of something that might help some younger lawyers. I don't really know who's on the feed right now. None of the lawyers I can see would make that mistake now. And I promise you that's the last time I made it too. So that's just something kind of basic. And the other thing I wanted to talk a bit about mentoring, because it ties into this, I think. There's not a lawyer I can see on the screen right now that I wouldn't ask for advice on a case. I've been practicing 19 years, and there is no shame and there is no stigma to asking somebody that knows more than you do how they'd handle something. I know Bob's a very jovial guy and very smart and very good. We all know that. Certainly Bob is willing to help a member of this end when they have a case where they just need some guidance. So that's one of the things we're going to try to bring in the mentoring program. And I don't want to shift focus totally to that, but I think they're related. And I think there's at least two people I can see right now that I, in the past, have asked for work, and not for work, for help. And they're always glad to give it. So I know we're kind of winding down and getting close on time. So that's really all I have, but I'm happy to be a part of this tonight. So thank you all.
Thank you, Chuck. Cliff? You're muted.
The thing I was going to talk about was choosing your battles, and that was something kind of stuck in my mind. So I've been practicing 18 years, and first couple, you don't, well, I didn't try any cases the first, at least 2 or 3 years. And after we started trying cases, I realized after another, 8 or so that I hadn't picked a single one of my trials. And I only do civil. I don't do criminal or family. So I don't know how this translates over. But on the injury and wrongful death side, I realized that every single trial I was going up against was because we were going just because we had such dismal offers that we had no choice. And I learned pretty quickly that none of my cases are as bad as I thought they were going in, but I was like, you know what? I'm going to pick some now. And so, and there's nothing wrong. And I think, I'm not sure if it was Bruce. I think Bruce mentioned like, if it's going to happen, getting your ass kicked is going to happen. And I think if you're not getting your ass kicked once in a while, you're not doing it right. I look up to the guys who are still in the trenches and battling hard cases. And that's who I want to hear from. Because you don't want to be the guy or lady that cherry picks. And so at some point I started picking cases out from the beginning and grooming them from the beginning and grooming the client to go to trial. And it's hard and it doesn't always happen. But once I started doing that, it changed my whole practice, because then grooming them for trial became what I started doing to almost all of them. And this is just in like the past 5 years, maybe 6 years, I started doing that. And now as soon as I sign the client up, I start thinking about my closing arguments, what it's going to look like. And then every time I take a deposition, I'm starting to look at how am I going to word this and how am I going to put this in. And I think it's helped as far as getting my ass kicked once in a while. I hope to still get my ass kicked once in a while, but at least now you also have some where you're not just the nail, so that's kind of something that stuck out into my mind.
Thank you. And Sharon, I wanted to come back to you because you had made an additional comment when we were discussing things before about a mistake that you make even as a more mature lawyer as far as over trying your case.
Yeah, so, a recent, it feels recent. What was it, 2016? I still think about it every week because it burns. I have PTSD over it, I'm sure. But I think about that case a lot, and it was a large case. And I think about how is it that this case I was so sure about and prepared for years, mock trials, you name it. We threw everything at it. And how do we lose this? Because there was really about 5 or 6 ways to win it. We had numerous counts. All the jury had to do was pick one that fit. And there's about 10 things that I would do differently in that case. I still think about it. I'm sure I'm damaged by this. But one thing I will say is I will try very hard not to over try a case again. Because the jury needs one theme, one story. And when it comes down to trial, you just got to pick one. Pick your best one. Don't try to prove that this person is a fraud. And if he's not a fraud, well, then he just made a mistake. Okay, pick one that really fits and go with it. Rather than giving the jury too many options that might make it complicated. And I think sometimes that I get so gung-ho about proving things that I somehow take on a burden of proof that I don't even have. I find that when I'm defending cases, I have to remember this is not even my burden of proof, but I take it on as though I have that. And I think it's really important that you keep that focus that, okay, they're the ones that have the burden, and the jury needs to understand that it's not my burden. So I think we just have to not overdo it. And, Bob always says, keep it simple. What is it? Stupid? I don't know. Keep it simple. But keeping it simple is the way to go. I mean, I teach trial advocacy at Stetson this semester, and I try to tell the students, look, you've got several different ways to go with this. Pick one. Don't make it so difficult. Keep one story. And I think that it's very hard to remember when you're engaged in a complex piece of litigation that really all that matters is what is a fifth grade mind going to understand? What's the story that they can accept? And so I think that keeping it simple, keeping a simple theme, a simple story, keeping your elements of proof, simple and described in a way that's understandable is really the best way.
Thank you. And Bob, there was something else that you had mentioned previously, and maybe you did mention it when you were speaking, and I just didn't catch it. But you had made a point before that we, as trial attorneys, we are exhibit number one, that our credibility with the court matters, and it can carry a lot of weight. Did you have anything to say, I guess, in support of that position or expand on that?
Yeah, I think so. The basic principles of persuasion have never changed. And back to the times of Cicero and Aristotle, and it's, it's one of them, is ethos, okay? The ethics of it, pathos, logos is the logic of it, and who the speaker is. We've all run into people that after a while, it doesn't matter what they say. We don't believe a damn word that comes out of their mouths, okay? So you are the one, you want the jury or the judge to choose you as the guide. You want to be the one that's got the credibility. If you've got a weakness, you're going to be the one that brings it out. You're going to be the one that divulges it. You're not going to be the one that, distorts it or does any of that. You are exhibit one. If you understand, you are exhibit one in that trial. That's critical. That is, the speaker, the integrity of the speaker still counts, okay, as much as it did back in, ancient Greece.
So we have a few minutes left. I just wanted to expand on one thing that Judge Day said about slaving over that memo of law and then handing it at the last second. He said, get with the court, find out when and how to give it to the judge so that there's enough time for the judge to review it. A lot of the judges do have their procedures for those attorneys maybe who have not been practicing as long, but on JED6.org, you can find the judges' practice preferences. Most of them have it up there. Most of them have updated COVID practices. And so they will tell you an even longer period of time that they want something before a hearing. If they don't, it usually says when the last time they updated their preferences were. Then, like Judge Day was saying, call the JA and find out, because otherwise, really, what's the point other than you're prepped, but the court, isn't. Did anybody have any questions for the panel or any other comments or input?
I
You'll have to unmute yourself.
I wanted to just say something about what Judge Day said. I was in a hearing in Tampa in front of Judge Arnold, who's now retired Hillsborough County judge. And there was a lawyer on the phone from Minnesota. There was probably 20 lawyers in that room for that hearing. And the lawyer starts off, Your Honor, I don't think they're reading the statute correctly. I don't think that this, and I don't think that. I think the subsection really means, he just keeps going on. When that lawyer got done, Judge Arnold looked around the room and says, does somebody want to tell me what this case is about? It absolutely is about the listener. When Judge Day said that, that is the most, it is about the listener. It's not about what you get out of your mouth. It's what does the listener need to know in order to, in this case, make that decision.
I'll be a little more blunt. this is no reflection on Jim Arnold, who's a friend of mine that I appeared in front of a lot as a lawyer. But I don't think anybody ever lost money underestimating the acuity of the judge.
No disagreeing. Anybody else?
That sucked all the oxygen out of the room, didn't it?
Well,
Way to
here
go,
is
man.
nobody here is willing to walk into that trap, Judge.
I could say it. I could say it.
So I did want to thank, I didn't do it earlier, and I think I forgot to do it last time. I'm really bad at this, I'm sorry. But I did want to thank the judges that did attend our meeting today. Like I said before, our very distinguished, experienced retired Judge Day. And we also had Judge Burgess. We have newly sworn in Judge Samatovich. We had previously, she had to jump off, Judge Caminos, and we also have Judge Reba on today. Does anybody have any final remarks, either from the panel or from the board?
I just want to say, if I can get, I know I've talked too much, which is always a problem, but I wanted to
No,
mention
keep going.
this is a Tom Masterson story. And Tom has passed away, and he was a phenomenal lawyer, and like great trial lawyers, he was a great storyteller. This was a case he lost. He co-counseled this case. He was the second chair. He was there to just assist, so this wasn't on Tom. It was a guy who was injured, who had injured his testicles were injured by something the defendant did. Okay. And when the client is up on the stand, not prepped by Tom, and Tom loved telling the story, he said, my testicles were discolored, and the defense attorney said, what color was they? And what color were they? And he says, magenta. Okay. All right. Worse than that, and I hate to end on this note, but it is remarkable. Tom's co-counsel puts the guy's sister on the stand, and she's talking about, she's a before and after witness with a brother. And at one point she says, she's talking about, his testicles. And the question is, how would you know? And the plaintiff says, he showed me. And that was the end of the case. They got zeroed out, okay? And the only good thing that came from it was that Tom got to tell that story for the rest of his life, okay? So it just fits back with what Shireen says. Really, you really got to grill your clients. You really got to take them through. You really have to know what their testimony is going to be. You're going to get surprised anyway, but it gives you a chance to cut down on the mistakes.
Okay, I don't want to be connected to the testicle story.
Too late.
Too late.
That was great.
Well, on the magenta testicle note, thank you everybody for coming to tonight's meeting.
All right.
And we will see you on October 22nd for the judicial panel.
Thank you,
Thank
Carrie.
Everybody have a great night.
Thank you. Thank you, everyone.
Thank you.
Bye.
Bye.